guaranteed of their rights.
Okay. Wakili Miyawa, as you come in, the presumption of innocence until proven guilty stands. And as we speak about these graft cases, it's proper to note that the DPP is mandated by law to make the decision to charge. So let's talk about the prosecutor. How do they make that decision to charge? What's the legal requirement to start graft proceedings of an accused person? What's the evidence threshold, as per your understanding?
Yeah, thank you so much, Jesse. Yes, indeed, it's the DPP, the Director of Public Prosecution, who is the repository of the mandate of public prosecution. It's a constitutional mandate. And the Constitution stops there. The Constitution doesn't provide framework, it doesn't provide guidelines. So those guidelines, the DPP, the former DPP, came up with what he called the decision to charge in 2019. And it provides for a process. So talking about the legal underpinning of how a decision to charge is made, it is provided in law. It should not be a whimsical decision, or at least a politically expedient decision. Now, in the decision to charge, the first thing that a prosecutor looks at is what they call the key evidence. The key evidence, the basis upon which you can identify the person who has committed the crime, and you can also identify the elements of the crime. That is to say that once the police conclude their investigations and they come up with a police file, that file is handed over to the DPP. Okay. At that point, there is a presumption, or at least there should be a presumption, that there is what we call the key evidence. So the key evidence is there that leads you to the person who committed the crime and the crime that person has committed at the very beginning. Now, then the second stage that the public prosecutor makes is whether that evidence is sufficient enough, whether it can sustain a conviction, even by just merely looking at it. Then the second question the prosecutor asks himself is it in the public interest? The reason why they have to ask the public interest consideration is that normally prosecution is not the only way of realizing criminal accountability. There could probably be others. There is asset seizure these days, or forfeiture, there's reconciliation, mediation. There is even a civil process in which, if once it is established that somebody has illegally acquired public assets, you can even file a civil case. So the traditional notion of prosecution is not the only one. Now, that is how a prosecutor ends up with the decision to charge. There is key evidence that leads or points to the person who has committed the offense, and the offense itself, and the person who has committed the offense. That is the reason why we say that later on, when there is a complete volte-face and a decision is made to withdraw the charges, the question then should be, where is the key evidence, the basis upon which the prosecution was instituted? Has it finally disappeared? Has it finally doesn't point to the person who committed the offense? Does it not it doesn't point to the offense that person has committed? So those are some of the questions that I think the court need to interrogate. That is, however, not to say that we have completely, the person who makes an application to withdraw a charge, really the benefit, the constitutional right of the presumption of innocence doesn't apply. No, it still does apply. And by the way, the prosecution is merely a process of establishing the truth or not, or the guilt or the not guiltiness of a person. Okay. It is not a condemnation. Really, it's not a condemnation. So it's a decision that only the court can make. So,
Wakili Miyawa, still with you, because my limited legal knowledge leads me to understand that if the glove does not fit, you must acquit. We all know of that famous case. But what exactly is the standard legal process when it comes to withdrawal of a graft case from the courts? What's the threshold that perhaps hasn't been met in some of these high-profile graft cases that raises eyebrows, especially when it's the prosecution that says, hey, hold up, I don't think I have enough evidence,
Two things that I think in my analysis I have made. One is the way first in which the DPP understands their mandate or understands their role. In my view, I think the DPP is still minimalist in the understanding of the mandate that the Constitution has conferred upon him. That is the reason why he thinks that whenever there's a criminal offense or there's a conduct that is alleged to constitute criminal offense, prosecution is the only way. The second thing, which I think is which I think is responsible for the withdrawal of these cases, is the rationale or the basis upon which these decisions are made. They are politically convenient and expedient prosecutorial processes. Now, whenever political biases are embedded in the prosecution process, you realize that you are actually offending Article 157(11) of the Constitution that talks about 1, public interest, 2, the interest of justice, and the disinclination to abuse the criminal justice processes. That is the reason why you realize that sometime 3-4 months or 2-3 years later, there is what we call the complete volte-face to withdraw these charges because of the political biases that these office holders take or perceive these cases. And I can give you several examples. One of them, and I think the former DPP, who's now the director of NIS, actually he made a political confession a few months before he left the office. And he said that he was receiving pressure from the DCI. Remember, and of course the DCI was receiving that pressure from the office, from some higher office. And remember, under the Constitution, the DPP cannot be directed by anybody else. It is him who has the mandate to direct the Inspector General of Police. Remember, the Minister for Interior cannot direct the Inspector General or the DCI to make any criminal investigations or any criminal allegations. Only the DPP can. How did it become that the DPP was acting under the instructions of a junior officer? That was a clear constitutional violation. So that is the reason why we end up with withdrawals. In terms of the law of withdrawal, of course the DPP has the power to withdraw cases at any stage before judgment. That withdrawal has constitutional safeguards. You know, it's not a blank check. It must conform to one of two things. One of the things, I think Justice Sifuna has explained that, look, when it comes to the issue of the sufficiency of the evidence, and when you talk about evidence, you talk about relevance, admissibility, and reliability, the DPP or any officer under him in charge of that case cannot make that decision. That decision can only be made by the court. So on the question of the evidence, of course, which will lead to absolving the person or incriminating him, it is now far removed from his mandate. It is only the court that, and I think Justice Sifuna is right in that regard. The other thing, which I refer to as a minimalist understanding of the mandate of the DPP, is that, by the way, there has not been a complete mental shift in that office to the context of the 2010 Constitution that requires, one, accountability for everything that you do. People are still tethered to the old archaic culture of how prosecutions were conducted in this country, where the Attorney General those days would rise up one day, and of course he would direct the DPP, who was then under his office, to just go and stand before the court and withdraw the case. That cannot be constitutionally viable in the post-2010 constitutional dispensation. There must be accountability and explanation.
So Sheila, talk to us about the same issue in terms of threshold of